Ladies and gentlemen, welcome once again to Customs and GST Advisory channel of CustomsGST.com. Today we are not going to discuss merely Rule 86A, we are not going to discuss input tax credit. We are not even going to discuss GST today. We are going to discuss something much bigger, a question that strikes at the heart of constitutional democracy. A question that every lawyer, every chartered accountant, every tax officer, and every taxpayer must honestly ask: can software become law? Think carefully, not whether software can implement law, not whether software can assist law, but can software itself create legal consequences? Can a computer portal decide rights? Can an algorithm impose liabilities? Can GSTN do something which Parliament itself never authorized? Because if the answer is yes, then India has quietly witnessed a constitutional revolution, without Parliament ever amending the Constitution. Every day, millions of taxpayers log into GSTN. The portal asks them to file returns, upload invoices, claim ITC, reverse ITC, pay tax, generate e-way bills, generate e-invoices. Everything appears perfectly normal. Until one day, the portal permits something not authorized by law, not because Parliament amended the law, not because the Supreme Court delivered a judgment, not because a High Court stayed your registration, but because the software permit negative ITC balance not authorized by law. Now ask yourself, is that permission not intended by law is merely technical, or has software created a legal consequence? Because there is a vast constitutional difference between these two. Today our discussion is not about computers, it is about sovereignty. Who governs India, whether laws made by Parliament governs India, or software of GSTN or EDI systems of customs, whether problem in algorithm can create legal consequences, whether such algorithm is still in operation after its illegality declared by various high court judgment. Law is created only in one manner. Every constitutional democracy rests upon one simple principle: laws are duly made. Not by computers, not by bureaucrats, not by software developers, but by the legislature. Article 245 gives legislative power. Article 246 distributes legislative competence. The Constitution nowhere recognizes Google, Microsoft, NIC, GSTN, or software developers as lawmaking authorities, because sovereignty belongs to the people. The people elect Parliament, Parliament makes law. Everything else merely implements it. The phrase rule of law sounds philosophical. It is not, it is intensely practical. Rule of law means no person and no authority acts beyond powers granted by law. Please notice something remarkable. The Constitution says government is subject to law, it never says law is subject to government. And certainly law is not subject to software. What is software? Software is not legislation. Software is not delegated legislation. Software is not subordinate legislation. Software is merely an administrative tool. Just as a calculator cannot change mathematics, software cannot change legislation. It merely performs instructions. If the instructions are wrong, the result will be wrong, but software cannot transform error into legality. In last decade there is dangerous shift, something subtle has happened. Earlier, government officers interpreted statutes. Today, software increasingly determines outcomes before any officer examines the matter. The officer often says the system is not permitting. Pause, think about this sentence. The system is not permitting. Where is this phrase found? Not in the Constitution. Not in the CGST Act, not in the rules. Not in any notification yet. Millions of taxpayers hear it every year. This is the constitutional paradox. Suppose Parliament permits something, but the GSTN portal blocks it. Which one actually prevails, GSTN or Parliament? If the GSTN portal prevails, then actually GSTN software has overridden Parliament. If Parliament prevails, then the GSTN software must be corrected. There is no third possibility. Let us examine familiar examples. Rule 86A authorizes blocking of available credit. Suppose the portal creates -25 lakh. Did Rule 86A authorize this negative entry? Or it was invented by GSTN software? That is precisely the controversy examined in Same Alloys India Private Limited versus State of Gujarat, where the Gujarat High Court held that Rule 86A of the CGST rule permits blocking of available credit only and does not authorize creation of a negative electronic credit ledger. After the Supreme Court's decision in Cosmo Films Limited relating to mandatory fulfillment of pre-import condition in advance authorization scheme, the Honorable Supreme Court's permitted reassessment and payment of IGST and claimed the credit of paid IGST. Yet taxpayers have often encountered the response, ICEGATE does not permit reassessment of bill of entry without interest as mandated by Mahindra versus Union of India, 2022 by Supreme Court. The practical question becomes, can ICE's software architecture defeat the legal effect of a Supreme Court judgment? If the law recognizes a remedy, administrative technology should ordinarily facilitate, not extinguish that remedy. Imagine tomorrow GSTN introduces a new validation. The validation has no support in the Act, no support in the rules, no support in any notification, yet every taxpayer is prevented from filing returns. Has Parliament amended the law? No. Then what has happened? A computer program has effectively created a new legal consequence. That is not merely a software issue. That is a constitutional issue. Let us now conclude the debate. This debate is not about opposing digital governance. Digital governance is essential. Efficient software makes compliance easier, reduces human error, and improves transparency. The constitutional concern arises only when software begins to determine legal rights or impose practical disabilities beyond what the law itself authorizes. In a constitutional democracy, the statute must govern the software, not the other way around. If a conflict arises between the text enacted by Parliament and the functionality of a portal, it is the portal that must change. The Constitution does not recognize system limitation as a source of legislative power. And that leads us to the next and even more important question. If software cannot make law, can delegated legislation authorize software to do what Parliament itself did not? Thank you for watching. Like, share, and subscribe this channel. Press the bell icon for new notification. We will come back with new interesting topic.